And thank you. Thank you, Brendan. Take it away.
All right. Thank you, Addie, for the nice introduction. Is everybody seeing my screen at this point? I'm assuming that's a yes. Just going through the list of registrants and seeing who's actually here. It's good to see some familiar faces. I've worked with a lot of you, and I'm working with a lot of you currently, so it's nice to sort of reconnect. Also want to thank my cousin and my wife for joining the presentation. I've asked them not to, but they are. So I'm assuming this will end up with my mom in no time. So without further ado, the purpose of today's sort of presentation, just to give you a sense of what we're going to be talking about, is essentially design professional contracts with owners. I've worked with many of you in the past in negotiating these contracts or coming up with your own terms and conditions that you can send to your clients. But oftentimes, until a claim actually comes in, the design professional is sitting there saying, well, why does this really matter? And I'm hoping to sort of cover that at a sort of higher level here today. So we're going to be talking a little bit about the standard of care and where else it may be impacted elsewhere in your contract. We're going to be talking a little bit about indemnification and what to watch out for if you are agreeing to indemnify a third party, oftentimes being the owner. There's been a recent sort of uptick, at least in my experience, in seeing owner requests to increase insurance limits, and those aren't going away. And I just want to give some thoughts on how to deal with that. Limitation of liability provisions, consequential damages, arbitration and litigation, and other considerations to limit exposure. I guess before I actually jump into the if I don't know you, you probably know my partner here, Becky Farnham. We do professional liability work here in Maine and New Hampshire. I would say 85% of my practice at this point is defending design professionals in negligence and malpractice lawsuits. And that's, I think, what Addie was referring to earlier with, well, if you don't know me yet, you probably don't want to. But I somewhat disagree with that. I'm here, Becky's here. I'm on a more limited role, but we're here to sort of help you on the front phases of the project to get your contracts into a position that you can avoid downstream risk. So I'm happy to share my contact information after the program, but most of you know where to find me. Contracts matter. Why? They set expectations for the parties, and oftentimes, contracts are viewed as something that is you're asking too much for, or you don't want to get bogged down into the minutia of contracts. But I think it's an opportunity early on in the project to get to know your client, get to explain to them what's going to happen in the project, when it's going to happen, and why it's going to happen. And it really sort of sets the stage for solving problems later down the line. And it really helps in terms of distributing and mitigating risk for both you and the owner. When there is no contract, or the contract is pretty limited, that's where the gray area comes about, and the disputes between the owner and the design professional sort of happen. I presume most of you, and I understand there's different folks on today's presentation. I presume most of you have at least heard the phraseology of standard of care, or the phrase standard of care.
I don't want it like that.
Somebody's mic isn't muted. And the law in Maine and elsewhere recognize that design professionals like doctors, lawyers, and accountants and other professionals does not require perfection, flawless results, a warranty or a guarantee. And what they really is looking for, and the law requires here in Maine, is that you exercise judgment and skill consistent with those in the industry. And these are just two cases from Maine that I've picked that actually speak to the standard of care. The first one involving a physician, but that's no different for a design professional. And the other one is actually taken from the Maine jury instruction manual as to what is required to be considered professionally negligent. And I suspect most of you understand that and know that, and that makes sense. But and in the model language and this is taken from the AIA, speaks to that. It's consistent with what Maine law and laws from other jurisdictions require, essentially that you're providing the skill and care that an ordinary competent architect and engineer would provide, practicing in the same or similar locality under the same or similar circumstances. So in essence, what the standard of care does is that you as a design professional is being judged against the conduct and practices of your peers and not necessarily the end result. And that's where you want to be at. But through contract modification or other language elsewhere in the contract, you can be altering that standard of care and unknowingly essentially turning a good contract into a bad one fairly quickly. And so if you haven't, you might see if you're doing government work or work for a sophisticated client like a college or a school department or a hospital, they can sneak in words in there in the standard of care about highest, best, most qualified. And those are easy to spot. And if you do see them, I would push back on them. The purpose of, or where I want to focus today's presentation essentially is those other provisions where it's not so obvious. And my hope is to, at least when you're looking at a contract for the first time, you sort of remember something from today's presentation and say, well, maybe we should think about this more, or even contact Brendan. And these are common contractual terms that are found in contracts that I've actually seen played out in claims. And so the first one is, this is taken from an actual contract, and I know at least two of you on today's presentation might be familiar with this contract, but this is taken from essentially another design consultant, standard terms and conditions, which actually speak to the design professional and its consultants as buyer and seller. If you're seeing the terms buyer and seller in a professional services contract, I would already throw some caution at that. That to me is more of a purchase order that a manufacturer would use. But if you're taking this as an example, and you can see it elsewhere in other form contracts, but essentially that you as the design professional are agreeing to comply with all laws in performing your services. And oftentimes, and I've seen it before, not necessarily all laws, whether they be federal, state, or local, are consistent with one another. But you as the design professional are using your best judgment to comply to the extent possible. This to me is almost setting yourself up for failure in the event that you don't check all the boxes on federal, state, local laws. So I think, when I see language like this, it's modified. And, we include some disclaimers to the extent possible. The design professional shall comply with all applicable federal, state, local laws. To me, by not including that disclaimer, you're essentially guaranteeing or warranting that the project is going to be consistent with all applicable laws, and sometimes it's just not possible. Another area is where you see warranties in your form contracts. Design professionals, again, going back to the standard of care and what Maine law requires, are not in the business of giving warranties. Warranties is something that's given for products, not services. So if you see the terms warranty in a form contract provided to you by an owner, I would raise a red flag quickly on that. At most, and as this one does, is you're agreeing to warrant that you'll perform the work in accordance with the standard of care. To me, that's duplicative of agreeing to perform work consistent with the standard of care, but here it's framed as a warranty. My hope would be that a provision like this would be struck out entirely, but if you are in negotiations with an owner and it's a topic that they won't budge on, at least warrant your services to adherence to the standard of care. You're not giving up much there. The problem that I have with this provision is that, okay, in the event that you do not comply with the standard of care and essentially your negligence, it's the second portion of this provision that sets you up for failure. And essentially it's stating that if you do not comply with the standard of care, then you are responsible. Again, seller and buyer, seller being the party having the prime contract with the owner, and the buyer being the subconsultant to that design professional. Is you're on the hook for all direct, incidental, consequential damages and any other costs arising or in connection with the non-compliance. And in terms of damages, that is pretty broad. That to me reads as you're on the hook for anything under the sun or anything that may result from your breach. And that is not what the law requires. And so be on the lookout for warranties. If you see it, you're going to want to get something like that removed. Another area that can sort of modify the standard of care is what your deliverables are. And this is language that was added in to a standard AIA contract by counsel for the owners, where in speaking to the construction document deliverables, they included the word that the construction document shall be complete, accurate, and buildable. And to me, probably all you know here, the old phrase, that there's no perfect set of plans. And here you're setting yourself up for failure by agreeing to provide a complete set of plans. So watch out for words like that. They're unnecessary, and they may be impacting the standard of care that's actually required. This is another example taken from a standard AIA contract, which was modified by the owner, but with a lot of sustainable projects going on now, and the certifications that come at, or that's hopefully to come at the end of the project, is sort of providing a guarantee of that result. This is contract language about speaking that upon completion, the project will attain some certain level of this certification that the owner wanted for the campus as a whole. And you as a design professional agreeing to something like that early on in the project without sort of knowing the extent of who the contractor may be, or who the contractor subcontractors may be. You don't want to be guaranteeing results on the performance of the building envelope or installation package when you don't know the full scope of the story yet, as well as the fact that there's going to be a handful of other folks working towards achieving that ultimate certification. I've seen claims based on this before, language similar like this before, and there's not much you can do if without getting into the slippery slope of, well, you guaranteed us the results. Be cautious of that. If I see language like this, I usually modify it to say, the design professional will endeavor to achieve certain certification at the end of the project, not will or shall. I'd also be wary of sort of the own forms that you as a design professional are using on the project, even outside of the contract itself. A lot of you are obviously providing contract administration services during construction phase, and reviewing either submittals or going to the site and doing site visits. And you just want to make sure that the forms that you are using are consistent with what the actual contract requires. And this is an example of a submittal review stamp that's being used by a local architect that spoke to reviewing the submittal by the GC, and the language says, approved, but implicit in that, or expressly stated in the language on the stamp, is that review is for conformance, and essentially goes on to read review is for compliance. If you look back at the contract that was being used in that instance, the contract says general compliance or general conformance. So just be cautious of the forms that you're using that might be sort of guaranteeing a certain result, or giving the impression that a certain result is being guaranteed. I would modify this submittal review stamp to say general conformance and general compliance, so that it's actually consistent with the contract. And that goes for, language on a field report as well. Another example is, and this is language taken from an AIA contract, is certifications for payment for the contract, or certifications of substantial completion, certifications of project completion. The AIA uses the term certify as its standard terms. I suspect other form contracts, the EJ, CDC documents use the same, but I'm using this as an example here. I've had claims based on this very language about certification of payments. Hey, you as design professional approved this payment. We rely, as the owner, we relied on you. Had you done a better job, we wouldn't have made the payment, and we wouldn't be in the position that we are today. Certify gets close, or runs close to providing a warranty or a guarantee of an end result. So whenever I see the term certifications being used in a contract, I will add language to sort of reestablish the fact that the owner is acknowledging that the above reference certification is not a warranty nor a guarantee that the work performed by the contractor is in strict accordance with the contract documents. If you're only providing, site-based visits twice a month, but approving payment for all the work, you want to make it clear that you're not necessarily certifying that all the work is entirely consistent with what's required in the contract documents. Many of you may already be doing this already. For those that are not, just something to look out for. I think certifications at the end of the project, whether it be for structural engineers that need to certify something for the city, whether it's special inspections or just certifications in general. Be wary when you are signing or entering into negotiations on a contract as to what representations or assurances you are going to be required to provide at the end of the project. You might be required by your contract to provide a certification to the city of Portland at the end of the project that it complies with X, Y, and Z. Well, if you provided design services as part of the contract, but not necessarily contract administration services or site visits, or a handful of site visits, you just want to be cautious as to what you're going to be asked at the end of the projects, so that you're essentially not biting off more than you can chew. by knowing in advance what sort of representations or assurances you're going to have to be giving to a governmental entity at the end of the project, you can might be able to negotiate for additional site visits to the project on the basis that if you're going to be asked at the end of the project to certify something, that you're going to want to make sure that you've actually been there and observed the construction so that you can certify the result. This is probably no surprise to anybody, but you have your contract and it's been negotiated and you have it in a position where you like it. And then at the end of the day, the owner wants to include their own standardized terms and conditions for how the project is going to be managed and what deliverables are required. This usually happens in healthcare settings or institutional clients or colleges, universities that have their own staff that of architects or engineers that know exactly what they want. You just want to make sure that in reviewing those additional terms and conditions that are going to be incorporated into your contract, that you're not undoing all the work that you did in sort of taking care of some of the issues that I've highlighted already. And when dealing with sort of the negotiations or the pushback on the owner on some of these terms, I often phrase it and work with either the owner or their counsel as, we're just trying to get this back within insurance coverage. It's no benefit to the owner to have uninsured claims or claims against the design professional that are uninsured. In the event that they are uninsured, they're going to be chasing the design professional for its, computers and copying equipment. Unlike contractors, most design professionals don't have a fleet of trucks or equipment that, at the end of the day, adds up to a lot. So, if you pitch it as we're just trying to get this back into insurance coverage, oftentimes there's a more of an appetite to have a discussion with you about negotiating those terms. So now could be a good time for questions if anybody has one. Those I know I ran through that pretty quick. If not, I will trudge along.
Brendan, there was a question from Deborah earlier. Would you recommend separating entities for design and build if you are a design and build firm to protect the standard of care provisions for the design portion of the work?
So the firm is a design build firm itself?
One would imagine that would be indicated.
Design build, that's probably the next lunch and learn that we probably spend hours on. Design build is interesting. I don't think in terms of, I've helped out a local design build firm in formulating contracts and their own terms and conditions. There is a lot of crossover, but if there's a way to do it right where you are still keeping the standard of care for the design portion of the work, while at the same time making clear that for the construction portion of the work, warranties, all the typical building warranties are being provided. It's a good question. I don't think it has to be. It's a good question. It's probably something that that I'd want to follow up with Deborah on and talk a little bit more depth on. So with that, I'm going to jump to indemnification. Indemnification is probably a term that some of you heard, others haven't. Indemnification essentially is where you as a design professional are agreeing to step in to the shoes of somebody else, most likely the owner, to pay damages to a third party. And why does that all matter? Well, if you are constructing a library or a new school and somebody trips going up the stairs and that third party is injured or a structural beam falls and hits somebody, that injured party sues the owner is going to be looking to you as a design professional if there's a design flaw error to pay those damages. And that's an example, I guess, of what indemnification means. Should it be included as a provision to a contract? Well, if it's not, I wouldn't say you want to go ahead and add it. You're just adding additional risk for you. But more often than not, it's a standard term in most contracts. And so if it is included, there are certainly areas or things that you want to avoid. And the primary one is if you are seeing the word defend within an indemnification provision, that at all costs should be removed. Providing a defense essentially is providing for another person's attorney. And that means essentially paying their attorney's fees. So if the owner is sued by a third party because that third party has tripped and fell going up the stairs, you are now on the hook for paying the owner's attorney's fees. And meanwhile, you haven't chosen who that attorney is or negotiated those rates. So the owner's using an attorney that's billing out at $400 an hour. That can add up quickly, and it's also uninsurable. And so you're paying that out of your pocket, not out of your insurance policy. Also, if there's going to be an indemnification provision within your contract, you want it tied. You don't want the damages to be limitless. If a structural beam falls in a gym and injures a handful of people, those damages can obviously add up fairly quickly. So you want to tie the indemnification provision, the indemnification provided to the owner, to either available insurance or just some other limitation of liability found elsewhere in the contract, which we touch on later. The other area that if there's going to be indemnification is I like to exclude the general contractor from the indemnification protections. We have had claims in the past that were difficult to resolve because every time that the general contractor submitted a change order or proposed change order as a result of a simple error or omission in our drawings that we believe are within the standard of care, the owner looked to us and said, well, this is a claim made by a third party. The general contractor is a third party, and under the indemnification provision, you need to pay the damages. To me, that's not the spirit of what indemnification provisions are supposed to be providing. They're supposed to be providing protection to the owner for truly third-party claims, not the general contractor's claim made in the course of a construction project. Here's an example of an AIA contract that was modified by the owner's council, where they inserted the language defend into the contract, as well as removed the language from the AIA contract that specifically says that the indemnification provision does not include a duty to defend. So we had to go back and forth on that. And ultimately we were able to come to some agreement on that. But, be on the lookout for that. They also struck from the language that the duty to defend is limited to the remaining amounts of insurance coverage. Again, I made the note earlier, that's something that at all costs you want to avoid. Another example here again is indemnification taken from that same contract discussed earlier, where both the design professionals are referred to as seller and buyer, but they have the word defend in there. And it includes all damages, liability, or costs, including attorney's fees and defense costs. Again, the defense cost portion is uninsurable, and you may be paying out of pocket for somebody else's attorney. I'm jumping to a different subject, so if there's any questions on indemnity, I'm happy to take them.
Yeah,
All right.
if just Brendan, sorry, anyone can unmute themselves and come on if they do have a question at these little pauses. So just feel free to do that if you do. Thanks.
I have a question about the indemnification. Our professional liability insurance advisor years ago recommended, because 98% of our client agreements, the clients always have the indemnification clause in there. So he recommended years ago that we do a mutual indemnification clause, and in particular include where the last part of the indemnification clause actually puts in, to the extent caused by the consultant's negligent performance of the professional services as provided within this agreement. And we always have our scope of services as an exhibit within the agreement. So that's what we're referring to. So that kind of protects us, I assume. Is that correct? Is the way you understand it?
Yes, and the model language in the AIA, the key language there for me at least is, you're providing the indemnification only to the extent that are caused by your negligent acts and omissions. That's within the AIA. But yeah, if you're going to provide indemnity, it should be based on the extent of your liability.
As related to the scope of services that we said we would provide.
Yep.
Right.
Yep.
Okay. Thanks.
So this is an area that is always a little bit thorny in contract negotiations. And you and your firm may carry $1 million worth of insurance coverage, or 2 million or 5 million. And at this point, it always seems like the owner always wants a little bit more. And I think about this, I've tried to identify some reason for why I'm seeing this more and more often. But if you've had a claim or had a mediation with me, and the claim also involves the GC, and it's clearly an issue of workmanship with the GC, and you're brought in because you failed to catch that error, the focus really turns on the design professional during the claim process. And part of that is, at least in my view, is what's sort of provided for in the respective insurance policies between a design professional and a general contractor. Pretty much, if you commit a wrongful act, which is defined, this is an example taken from a insurance policy, but most are pretty similar to this. If you as a design professional do a wrongful act, which is an actual or alleged negligent act or error or omission, you're going to have coverage. And again, if you're making warranties or guarantees, you may not have coverage. But if you are negligent or you make an error or omission, there's going to be insurance coverage for you. And so crafty lawyers can make sort of a claim that is covered fairly easily. On the other hand, for a general contractor, they do have insurance. Their insurance companies provide coverage for damage that the insurance applies. But there are, there's 20 or so exclusions to that coverage. One of which is, or two of which is damage to the product itself, which is, essentially the project, or damage to your work. So in essence, the insurance companies for the GCs do not provide coverage for faulty workmanship, for errors in reviewing plans, or for constructing in accordance with contract documents, their insurance company is not a guarantor of them doing a good job. And so you get into mediation and you have one party with insurance coverage, and the other without insurance coverage. Most often, when clearly the table should be turned, the design professional becomes sort of the primary target. And that I think is comes as a surprise when you're in a mediation or you're getting into the claim process for a lot of design professionals. And it's frustrating, I get it. But the reason, again, I think that we're seeing a lot more requests by owners to get additional insurance coverage out of the design professional is they know that if the claim arises, they want that money to be available through the architect or engineer. Most of you do have options to increase insurance limits. They're expensive. Whether you increase if you have $1 million policy and the owner wants a $2 million policy, you can upgrade your policy from $1 to $2 million, across all projects. But that's expensive. You can talk to your broker about getting a specific endorsement for that project or specific project insurance. But oftentimes you only get allowed 1 or 2 of those a year. And again, those are expensive. My recommendation, because I don't see this going away anytime soon, is upfront, before you are sending your client a proposal, is to get a sense of what the insurance limits they're going to be looking for. If they're looking for $5 million of coverage and you only have $1 million, then I would get the pricing in advance for either a project-specific insurance or limited endorsement if it's available. And if it's $60,000, which is no small sum, try to incorporate that into the contract price. It's because going through negotiations and having them pay for that after the fact, to me, has been difficult. This is an area that is negotiable. I've been successful. I've never had a client have to walk away from a project because the owners have requested, due to the owner's request for increasing limits of insurance. We've either, limited the time frame, limited the amount, had the owner pay a portion of it, not disclose it to the owner and receive it or get it and pass it on through the contract price. So there are ways to do it. It's just, I think, understanding why the requests are being made is sort of goes back to the specific coverages that are being provided for under both policies. The GCs and the design professionals. Limitations of liability. Limitation of liability, probably most of you are familiar with, but it's essentially a provision within your contract that sets the ceiling for your risk, sets the ceiling for damages that could be recoverable against the A&E firm. The best way, in my opinion, to do it is to have it tied to available insurance coverage. And with that, if you are, the key term there is available insurance coverage. If you have 2 claims in 1 year and you're depleting insurance coverage limits on another claim, you don't want to be setting yourself up for failure by not having enough insurance available to satisfy a limitation of liability provision in a different contract. If you can't tie it to available insurance coverage, you can, or as an alternative, if the fee is not a lot, you can tie it to your total fee for the project. Certainly you want to be, if you cannot get a limitation of liability tied to the fee or the available insurance, you're going to want to at least have a clause in your contract that they are not permitted to sue, the officers or directors, managers, or members in a personal capacity, so that you are avoiding personal exposure to the principals at the firm. We talked a little bit about indemnification earlier, and you want to make clear that if you're going to be providing an indemnity and you also have a limitation of liability of claims made against you by the owner, that indemnification provision, that the limitation of liability provision equally applies to your duty to indemnify as well. You don't want to get in a situation where you negotiated the risk with the owner if they're going to make a direct claim against you for a design error, and you've set the ceiling as the amount of your fee, but if somebody trips and falls, again, going up the stairs, and the owner asks for indemnification, at the same time, you are not limiting your exposure, that it's uncapped. So just be wary of that. The limitation of liability just is not endless. It does not have impact on direct claims made against you by third parties, since your agreement is only with the owner, and the sort of bargain for limitation of liability is only with the owner. If a third party sues you directly outside of the contract, the limitation of liability won't apply. There's an argument, and we would make the argument that it does apply, but there's no certainties that it actually does apply. Here are a few examples of limitation of liability provisions. Again, this is language that I would add to a standard contract that ties it to the amount of available proceeds of insurance or the architect's total fees, whichever is greater. Another example here is if we were in a scenario where we were unable to get sort of this available proceeds of insurance language or total fee, we limited the risk by having the owner and architect agree that the owner would not seek recovery against any of the architect's officers, directors, partners, owners, etc. Another example of a limitation of liability is setting a dollar amount on the limit. We had a claim where this was a provision in the contract. There was a limitation of liability for, again, $1 million, and the value of the insurance policy was $1 million. When a claim is made and you have $1 million policy and it goes into litigation, design professionals have eroding insurance policies. And so as soon as an attorney, or including myself, gets involved and we start working up the file or hiring experts to defend the claim, well, all that defense costs and expert costs are coming out of that $1 million. So if you go to trial and you've spent quite a bit on defense costs, and the claim comes in more than what's left on the policy, there might be a gap in coverage there. So my suggestion is, if you can avoid setting a dollar amount, or if you are required to, make sure you provide yourself a little bit of wiggle room in the event that you get another claim that erodes from that policy amount, or you actually have defense fees on that particular file or project. This is an example where, this to me is the cream of the crop. It has your standard limitation of liability provision set at a certain amount, but it gives the client the option to agree to increase that limitation of liability by certain increments, and you can pick and choose what you want to do. but they're going to pay a fee associated with that. And essentially, I like this because it, more often than not, if we have a limitation of liability provision and there's a claim, the owner's counsel is, essentially saying it's unenforceable. It was a take it or leave it. They had no option. It shouldn't matter. I like to point to, if the contract has something like this, I like to say, well, we gave the client every option to, if it wasn't satisfied that was enough, to negotiate with us and provide a small fee, essentially, to buy more protection. Giving the owner the option, I think, is a helpful way to later down the line make that limitation of liability provision more impactful or enforceable. This is probably a good stopping point for questions. Okay. Probably all of you have heard about consequential damages before. They're the scary part of a claim. They're essentially everything that isn't a direct or foreseeable damages. I think of it as everything other than the cost for repair. So because of a design error or an omission, something needs to be replaced, and the large laboratory can't be opened for 2 months, and the owner is out of revenue for 2 months because the project's been delayed. Those numbers can add up pretty quickly when it's only a $5,000 part that actually needs to be installed. At all costs, I would say you want to be avoiding consequential damages. Sometimes it's impossible in terms of negotiating the contract, but in the event that the owner will not give up on consequential damages, I often loop those in within the limitation of liability, so that there is some ceiling to those sort of unknown and certainly uncontrollable costs. The AIA and EJ/CDC form contracts do have waiver of consequential damages within them. Be wary if they're struck. Be wary if you're using a form contract provided to you by the owner, whether they have consequential damages provision in there. And also be wary of unilateral consequential damages provisions. If you're not allowed to get consequential damages against them, then they should not be allowed to get consequential damages against you. Arbitration versus litigation. Before sort of delving into those two areas, the recommendation is to have mediation first as part of the dispute resolution process. Most contracts require that at this point, but a lot of you folks within your insurance policies have a credit provided to you by the insurance company that if you if you resolve a claim at mediation within a certain amount of time, you get a credit back on your deductible. So if you oftentimes if it's mediation within 1 year of a claim being made, and you resolve it, you get 75% of your deductible back up to a certain amount. If it's within 2 years or 5 years, you get 50% back. So there's some benefit to you requiring that mediation be the first step to the dispute resolution process. If you're unable to do that, or you're unsuccessful at mediation, you have essentially two options, one being arbitration, the other being litigation. Arbitration is usually before a single arbiter or panel of three. They're usually attorneys with construction experience. The results they're typically less formal. Well, they're less formal than going and trying a case before a judge or a jury. But they're, in my experience, they're expensive as well. Arbitration has this sort of appeal to being less expensive than litigation. I'm not sure at the end of the day there's that much of a difference between the work leading up to arbitration and the work leading up to litigation. The downside with arbitration is if you lose at arbitration, it's binding and there's no appeal process. And so as lawyers, I guess we always like to, if we lose, we want to be able to appeal. If we win, we want it to be binding. So there's a catch-22 there as to what the preference is. With arbitration, you definitely get a more sophisticated decision maker. Litigation, you're dealing with a jury of your peers that may not necessarily understand the intricacies of mechanical system or structural calculations. So both are acceptable. My preference, I guess, at the end of the day, is largely litigation due to the fact that you could appeal the decision later in time. Other considerations when you're at least thinking about arbitration versus litigation is, and this is sort of a tactical decision, is I enjoy when I get a claim and I see that there are inconsistent dispute resolution provisions between the owner's contract with the design professional and its contract with the general contractor. In essence, what that means is if the owner is making a claim against both you and the contractor for water infiltration or something along those lines, they're going to be fighting it on two different fronts. They're going to be fighting with you in litigation and the GC and arbitration or vice versa. And I think that is certainly helpful to resolving a case earlier in the process when the owner is looking at the fact that they may have to do this twice. They might get inconsistent results, and there's no way that the GC and the design professional will be pointing fingers at one another if they're both in the same forum together. So that certainly is helpful. Again, not a deal breaker at the end of the day if you go the route of arbitration or litigation. The preference for most insurance companies and myself is litigation. Another couple other areas where you want to consider how you can limit your exposure is certainly with renovation projects. When you're being provided as-built drawings, or there's existing additions or the presence of asbestos and other toxic materials, you want to make sure that your contract takes into account sort of the unknowns. It's obviously different than building or designing a building from scratch. But here's just some sample contract language about having the design professional be entitled to rely on the accuracy and completeness of the services and information furnished by the owner. And immediately following that, there's some language about the design professional having no responsibility for the identification, discovery, presence, or handling of hazardous material or toxic substances. So that's a contract that, in my opinion, is pretty fair and is consistent with the scope of services provided by a design professional. If you see contracts like this, you can obviously tell there's a difference there. This one speaks to site conditions where the seller again warrants, the seller being the design professional, that the seller and its employees are familiar with the work, the site, and its conditions, and the other physical and other conditions, including without limitation, hazardous materials which may exist on site. Again, until walls are opened up, I don't know how you can make that representation that you are familiar with the site and all its physical conditions. That same contract goes on to say that the seller, again, the design professional, shall be solely responsible for compliance with all applicable federal, state, and local laws, including environmental laws. And so if I could see a claim or an area there where if there's asbestos on site, the owner's going to be looking at that and saying, hey, you're responsible. Goes on to say that the owner shall, the design professional shall indemnify the buyer for any loss, cost, or expense resulting from the seller's failure to comply. Again, something that to me is something to entirely be avoided, especially on a renovation project. So when I'm dealing with renovation projects, I like to include language within the contract that talks about the fact that the structure is being remodeled or improved or rehabilitated, and the fact that without some expensive and time-consuming destructive testing or exploration, that you as the design professional are essentially relying on the information that's known, and to the extent that there are unknowns that pop up that impact the project, that it's on the owner to bear all costs, losses, and expenses arising from those conditions. So whenever I see a renovation project or you're doing renovation projects, I would get out in front of it in terms of the knowns and unknowns. I talked a little bit about personal exposure before for the principals at the A&E firm. I always include language in a contract that sort of nips that in the bud and takes personal exposure off the table for the owner. There are some firms around here that not only do they sue the A&E firm for an error or omission, but they will sue the actual architect or engineer that stamped the plans. It's nothing, in my opinion, more than a sort of negotiation tactic or a scare tactic. But if that can be avoided as part of the contract, then obviously hope is to do so. Other sort of areas that I see often is betterment and contingency. Essentially, betterment is if an error and omission, or actually an omission does occur in your design, for example, you forget to adequately spec or draw in guest rooms doors for a 400-room hotel. Just by an oversight, it may seem sort of out there, but it happens. That you, as part of the damages, that the owner is not entitled to recover from you the cost to purchase those doors. It would have been a cost borne by the owner, regardless of whether they were included or not in the design. Oftentimes, claims are made based on a lot of costs that should be borne by the owner. So to get out in front of it with your contract and to address the term betterment, I think is helpful. And I've included some model language there. If there's, a cost in an increase in cost to sort of these doors to get them to the project site on a more expedited time schedule, or to remove work that had already been installed to install the doors, then you might be on the hook as a design professional for that as a result of your omission, but not the purchase price of the 400 doors themselves. And the last area that sort of I see as really being an area that drives a lot of claims is contingencies on the project. And not having a sufficient contingency or no contingency at all. Again, going back to the standard of care and understanding that there's no such thing as a perfect set of plans. There are going to be issues that arise during a project that whether it's due to an error or omission, that's going to add to the cost of the project. And if there's a contingency in place that you can eat from, then it helps. It certainly helps a smoother project. Problems certainly arise when the contingency is being spent on owner upgrades, unnecessary owner upgrades, or non-existent at all. And when there's no additional funding for a public safety building or there's the high school, the owner is going to be looking to the design professional to pay for these added costs. So key takeaways, in my opinion, are essentially to watch out for language that may equate to a warranty or that may guarantee certain results. Do not agree to a duty to defend. Do not agree to consequential damages. Obtain a limitation of liability if possible. Ask for insurance limits upfront and adjust your contract price accordingly. Mediation first. And for renovation projects without destructive testing or exploration, be cautious and limit your exposure. And project contingencies can prevent most claims, and push the owner to include an appropriate contingency and essentially give up the granite countertop. It'll make the project run more smoothly in the end. So with that, I'll take any other questions.
Thank you, Brendan, very much. Yes, everyone can come back.
And I'll get a sip of water.
Thank you. That was a long one. We would love to see faces. So those of you that have had your screens closed off, would be lovely. Thank you, Patrick, for joining us. Any questions? That was a lot. You may have to unmute yourself because I probably muted you as you came in. So everyone, if you do.
I have a question, Brendan.
Yep.
I think with respect to maybe the firm I work with, we were smaller in size for some time, but we've grown, and so we worked predominantly from like our own kind of custom built design contract for some time. We've always been a little hesitant about the AIA because with the clients that we work with, it seems pretty daunting and overwrought. And so I'm just curious, from your exposure to a variety of firms and sizes in the area, predominance of whether or not they do utilize the AIA contracts for their projects, or if more people do like these kind of more custom built type design contracts. I'm just kind of curious because I do see a lot of great benefit in terms of protections from AIA contract that's standard and true, and just like to hear some of your experience of that and what your recommendation might be for us to maybe, if it's something that you would recommend to predominantly use AIA contracts, for example, moving forward.
Yeah, I know where you work, and I know sort of what you guys do for work. You know, for me, if you're doing sort of residential, high-end residential projects, I think having, you know, your own scope of services with a standardized term and condition sheet is entirely appropriate. If you're doing condo buildings or hotels or larger scale projects, I think maybe transitioning in those projects and using an AIA, the owners for those are going to understand it. They're probably going to have counsel involved for negotiating those contracts. But for sort of the residential projects, I think it's okay staying clear of an AIA.
Yeah, I represent the commercial side of our firm, and so it's part of what our transition is with that. And so I think we're pushing towards that, and I think we need to do a vetting process with pushing that forward. So
yep, I don't think any developer would be surprised to get an AIA contract on a commercial project.
Great. Although yeah, great. I'll bite my tongue.
Oh yeah, yeah, and those are the ones that cause problems. Probably the ones that are pushing back.
Yep.
Any other questions? Please feel free to just chime in. It looks like a bunch of people like got to the edge of their seat, so I'm hoping that actually is a prompt.
Brendan, good morning.
Hello,
This is
Bob.
Bob. How you doing?
Good. How are you?
Good job today.
Thanks.
My question, strikes me a little close to home, but what are some of the common ways that someone that's suing you can weasel out of the limitation of liability. You're familiar with that I know one way. I didn't know if there were other ways and if there were ways that we can protect ourselves from those.
So there's, full disclosure, there's not great law in Maine particular to a design professional's limitation of liability. The times that, cases have applied limitation of liabilities are, when you sign a FedEx package and you agree that you're not going to, or the FedEx package gets destroyed, that the most that you're going to sue FedEx for is the value of the package, So there's not, and so when I say weaseling out, most owners council, if they're faced with one, will say, there's no case in Maine that says that this is enforceable. And we'll take it to the end and say that it's not enforceable. It's something called a contract of adhesion that we did not have the opportunity. It was a take it or leave it. We didn't have the opportunity to negotiate with the design professional on that limitation of liability. Essentially, it was forced down our throat. So that's what I'm talking about, weaseling out of the limitation of liability, and by at least giving the impression that the client has the opportunity to negotiate that with you. I can't imagine a court saying, well, why do you want more now? You had the opportunity before you sign the contract to negotiate it. But I know what you're talking about.
Any more?
And I guess I just, I totally understand I threw a lot at folks. I'm available. I help a lot of folks out with contract negotiations, reviewing contracts. So, I'm available to help. I'm not just available when the claim comes in. So.
And Brendan's email was included in the confirmation. Everyone was blind copied, and Brendan's email is in there. Everyone, I hope, has signed up for our e-blast. So there are ways. I do love the idea of a part 2, whether it's design build. I think you can talk to Deborah offline, but I think that that's really smart, especially as firms are exploring that more and more, we're seeing. So I think that that's a really brilliant topic, but I'll send out a survey to see. I'm also, of course, without ever losing an opportunity, I'm putting the link to our party next week where you might actually be able to share a beer with Brendan and chat about this over probably a pretzel with mustard or something of brewery fare. So you can sign up there. And again, this will be recorded, so you can share this. But again, Brendan is a phenomenal community resource. And I have to say, just to cover my end, Brendan is a lovely person to know. So you do want to know him. I just meant that you didn't want to find yourself calling him when you were in jail. So by all means, he is a very lovely person to know on all levels. So
Thanks.
Does anyone else have any more comments? It's 11:15. I had you scheduled until 11:30, but I'm also respectful of everyone's time.
I guess I would ask, I have a question again. I guess the most pushback that we typically get, even on our ad hoc contracts, is our limitation liability. And I guess either strategy about negotiation with the clients. Generally, if it's just a really small contract for just like feasibility or something, I just strike it out because it doesn't really apply too much. There's nothing that we're exposed to too much. But I guess the question is, like, is that a wrong thing to even suggest, or just advice about educating our clients about drawing sets aren't perfect? And I guess just looking into the language of what the IA says about liability and educating about. Because our clients come to us and say, like, well, you have insurance for a reason. And like, well, okay, but our insurance providers kind of need us to put something in there or else to help with them. So I guess, advice in terms of how I might respond to those kind of comments from clients.
So, I get that quite a bit is, why are we limiting your liability if you mess up? And, the response usually is, well, Why would you want to put us out of business? You know, and so the way I handle that is usually all right, you tell me what you feel comfortable with in terms of a limitation so that we can all live at the end of the day and we can continue to work, feed our families. But if you want us to limit our liability or at $2 million, we're happy to get $2 million worth of insurance coverage here. But for that added protection, let's talk about who's going to pay for that $2 million. Do we think it's needed? But if that makes you sleep at night, if you want 5 million, all right, we'll get 5 million, but it's going to cost X amount of dollars. You know, the way that you price the project or your fees is based on, you know, assuming that the insurance that you have is adequate. And that sort of goes back to my question of get out in front of it. What do they want for insurance? Why it matters to them. And so that's how I usually approach it is let us limit our liability. Let us, but at the same time, we can make you feel comfortable by having insurance, adequate insurance in place.
Thanks, Brandon.
Yeah.
Brilliant. Thank you, Patrick. Well, with that, you have an extra 10 minutes to make some tea, grab coffee, answer non-work emails. You have this in your calendar. Again, Brenda, thank you so much. And Patrick too is a PSA, both are PSA board members. Mark Foster is on the call. He's a PSA board member. Yeah, keep a lookout for more activities and events. We keep adding them. So this will be a chock full late spring, summer, and fall. So once again, thank you so much.
Thank you, Addie. Thank you, Brandon.
Yeah.
Bye-bye. Have a good weekend.